On Monday, the 14th of June, jury were called, all appeared. The Honourable DeWitt Clinton, Mayor, then proceeded to deliver the decision of the court, premising that the bench were unanimous in their opinion, but had left it to him to pronounce the reasons of that opinion.
The question, then, is whether a Roman Catholic priest shall be compelled to disclose what he has received in confession in violation of his conscience, his clerical engagements, and the canons of his church. This is an important inquiry. It is important to the church upon which it has a particular bearing. It is important to all religious denominations because it involves a principle which may, in its practice, operation, affect them all. But before we enter upon this investigation, we think it but an act of justice to all concerned in it to state that it has been managed with fairness, candor, and a liberal spirit, and that counsel on both sides have displayed great learning and ability. It is equally due to the Reverend Mr. Coleman to mention that the articles stolen were delivered by him to their rightful owner, Mr. James Keating. It is a general rule that every man, when legally called upon to testify as a witness, must relate all he knows. This is essential to the administration of civil and criminal justice. But to this rule, there are several exceptions. A husband and a wife cannot testify against each other except for personal aggressions. Nor can an attorney or counsel be forced to reveal the communications of his client. Nor is a man obliged to answer any question, the answering of which may oblige him to accuse himself of a crime, or subject him to penalties or punishment. Whether a witness is bound to answer a question which may disgrace or degrade him, or by confession of sins or vices which may affect the purity of his character, is a question involved in much obscurity. There can be no doubt that the witness does consider that his answering on this occasion would be such a high-handed offense against religion that it would expose him to punishment in a future state. It cannot, therefore, for a moment be believed that this mild and just principles of the common law would place the witness in such a dreadful predicament. With those who have turned their attention to the history of Ireland, the decision of Irish courts respecting Roman Catholics can have little or no weight. In that unfortunate country, the Catholic has been disenfranchised of his civil rights, deprived of his inheritance, and excluded from the common rights of man. This case, the People versus Phillips, is a great constitutional question, which must not solely be decided by the maxims of the common law, but by the principles of our government. We have considered it in a restricted shape. Let us now look upon it upon a more elevated ground, upon the ground of the Constitution, of the social compact, of civil and religious liberty. Religion is an affair between God and man, not between man and man. The laws which regulate it must emanate from the Supreme Being, not from human institutions. Although no human legislator has a right to meddle with religion, the history of the world is a history of oppression and tyranny over the consciences of men. And the sages who formed our Constitution, with this instructive lesson before their eyes, perceived the indispensable necessity of applying a preventative that would forever exclude the introduction of calamities that have deluged the world with tears and with blood. And the following section was accordingly engrafted into our state constitution. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever hereafter be allowed within this state to all mankind. Considering that we had just emerged from a colonial state and were infected with the narrow views and bigoted feelings which prevailed at that time so strongly against the Roman Catholics that a priest was liable to the punishment of death if he came into the colony of New York. This declaration of religious freedom is a wonderful monument to the wisdom, liberality, and philanthropy of its authors. The framers of our state constitution were the first legislators who had just views of the nature of religious liberty, and who established it upon the broad and imperishable basis of justice, truth, and charity. A provision conceived in a spirit of most profound wisdom, and the most exalted charity ought to receive the most liberal construction. Even the Constitution of the United States, it says, Congress shall not make a law respecting an establishment of religion or prohibiting the free exercise thereof. In this country, there is no alliance between church and state, no established religion, no tolerated religion, for toleration results from establishment. But religious freedom, guaranteed by the Constitution and consecrated by the social compact, it is essential that its ceremonies and essentials be protected. The sacraments of a religion are its most important elements. We have but two in the Protestant Church, baptism and the Lord's Supper, and they are considered the seals and the covenant of grace. To decide that the minister shall reveal what he receives in confession is to declare that there shall be no penance. And this important branch of the Roman Catholic religion would be thus annihilated. The objections which have been made to penance have been theological, not political. The language of New York's Constitution is emphatic and striking. It speaks of acts of licentiousness, of practices inconsistent with the tranquility and safety of the state, to acts committed, not acts omitted, offenses of a deep dye. It would be stretching it on the rack to say that it can possibly contemplate the forbearance of a Roman Catholic priest to testify what he has received in confession. To assert this as a genuine meaning of the Constitution would be to mock the understanding and to render the liberty of conscience a mere illusion. Although we differ from the witness and his brethren in our religious creed, yet we find no reason to question the purity of their motives or to impeach their good conduct as citizens. They are protected by the laws and Constitution of this country, and in the full and free exercise of their religion. And this court can never countenance or authorize the application of insult to their faith or of the torture of their conscience. The only course is for the court to declare that Father Anthony Coleman shall not testify at all. There being no evidence against the defendants, they are acquitted.
Thank you, Your Honor.
This is wonderful.
The general satisfaction given to every religious denomination by the decision of this interesting question is well calculated to dissipate antiquated prejudices and religious jealousies, and the reporter feels no common satisfaction in making it public. When this adjudication shall be compared with the baneful statutes and judgments in Europe upon similar subjects, the superior equity and wisdom of American jurisprudence and civil probity will be felt, and it cannot fail but to be well received by the enlightened and virtuous of every community, and will constitute a document of history, precious and instructive to the present and future generations. I ought to write it down. Good night. God bless.